Well, hello and welcome everyone to this employment law session. This is your live employment law session with me. I'm Lior Samfiru, the employment lawyer, and I'm here with you for you on this session answering your questions. This is where you get answers. This is where you find out about your rights. This is where you hopefully get those employment law issues resolved. So again, I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. Our firm, we practice and have lawyers in Alberta, in Ontario, and in British Columbia. So if you're in one of those provinces, we've got you covered. And a good place to start on your path to answers is right here, right now. If you are worried about your rights when you lose your job, ask the question. I'll tell you what you need to know. If you're worried about your rights because you're being bullied or harassed, mistreated in the workplace, want to know what to do, ask the question. I'll tell you. If you're being discriminated against, treated unfairly, let's talk about that. Ask the question. Maybe your job is no longer what it used to be. Your hours have been changed, your shifts, maybe your pay, your responsibilities, what to do. Is that legal? How can you deal with it? Let's talk about it right now. It starts by asking the question and giving me that opportunity to help you and, of course, providing you that guidance that you need. We have extensive rights across Canada, some of the best employment lawyers in the world right here in this country. Unfortunately, too many people don't understand what those laws are and what they do. And sometimes you can lose those rights by turning the other cheek, by walking away, by just not doing anything. Bad idea. So let's not do that. Let's make sure that you stand up for your rights. And a great way to start is asking the question right now. Now, I'm going to start answering questions in a minute, and I want you to ask them. But let me give you some other contact information. If you want to reach me privately, you want to have a private chat or a private email exchange with myself, my team, very, very easy to do. You see that address on the screen. You just go to employmentlawyer.ca. Again, employmentlawyer.ca, place to go to. And when you get there, first thing, of course, if you want, you can read lots and lots more about employment law and about your rights. But you can also get the phone number, the email address to contact us. Fill out a form instead if you prefer. We'll call you. Easy to do. It's all right there at employmentlawyer.ca. You know, if you need an employment lawyer, pretty easy. Employmentlawyer.ca is where you go to. But right now, you don't even have to worry about that. Right now, I am live here with you and for you, answering questions. So you have time. Type in the question. I will see it. I will read it. And of course, then I'll do the most important thing, which is answer the question. So let's make sure you get those answers right now on this session. All right, let's start answering questions. What do you say to that? So I'm going to start. Thank you, by the way, for joining me, Lior Samfiru, the employment lawyer. Our first question comes from D. I was recently terminated from my position without a concrete, solid reason in my exit meeting. I was not offered severance pay as they claimed me to be an independent contractor. Based on what I understand, I do not feel that this is right. I have reached out to them, but I have not received a response. Do I have a claim? So let's break this down. First of all, in terms of a reason, generally remember, an employer does not really have to have a good reason to let someone go as long as proper severance is paid. So an employer has to pay severance. That could be as much as 2 years' pay. But when it comes to reason, an employer is not required to say, hey, I have a really good reason. They can let go with no reason, bad reason, false reason. Not a very nice thing to do, of course, but they can do that as long as they pay proper severance. So the question is this person, is D owed severance? Now, it comes down to whether D is an employee or a contractor. It is extremely common for individuals to be misclassified as contractors when they are really employees. Think about it. If you have a regular 9-to-5 job, Monday to Friday, etc., you're an employee. If your company starts calling you a contractor, it doesn't make you a contractor. If you look like an employee and act like an employee, well, yeah, you're an employee. So I don't know enough about D here to say, I don't know if she works regular hours, how long she's been doing it, does she have other jobs? But I can just tell you based on experience, chances are that D has been misclassified and D is an employee. And if D is an employee, she's owed severance. And again, depending on the years of employment, that could be as much as 2 years' pay. It's a very, very common situation to be misclassified, okay? To be misclassified as a contractor when you really are an employee. So ask yourself this, do you work for a company or are you in business for yourself? If you're in business for yourself, you have a business with a bunch of customers, etc., then you're not an employee, you're a contractor. If you work for one company, guess what? You are an employee of that company. So very important, very common situation. I speak every week with people when they've been let go and all of a sudden they realize, wait a second, I'm not going to get severance because I've been called a contractor. Not so fast. If you've been misclassified and you really are an employee, despite what you've been called, you get your full severance. As I said, that could be as much as 2 years' pay. So great question, D. Hopefully that makes sense. What I want you to do then, D, is call me. Okay, connect me ASAP. I'll help you get that severance. Easy to do that. employmentlawyer.ca to connect with me and my team and get that severance and get our help to get that severance. All right, that was our first question today. Thank you for that. If you're just joining us, this is your live employment law session where you get your questions answered about legal rights, about employment law, about the rights that someone has in the workplace. I'm Lior Samfiru, the employment lawyer, and I'm going to continue answering questions right now, and I'm looking for your questions as well. Don't be bashful. There's nothing to be gained by being bashful, by not asking questions. Lots to be gained if you do ask your question. You'll feel better, you'll know more, you'll be empowered. So let's make sure that we do that as well. All right, let's see our second question today from CSP. I received 2 informal compensation benefits when I was hired, an extra week's vacation, and a few personal days. Fast forward to this year, a new supervisor, and my days have been rescinded, and now my extra vacation week is being taken away. Is the additional week of vacation and personal days considered a part of my terms of employment? Can they take away after 8 years? So it's absolutely part of your terms of employment, but that doesn't necessarily mean that they can't be taken away. And here's what I mean by that. An employer cannot make significant changes to terms of employment. And if an employer makes significant changes, that could be a constructive dismissal. Let me give you an example. So let's say your employer reduces your pay from, I don't know, $80,000 to $60,000. That's a significant change. That's a constructive dismissal. You would be able to consider that to be a termination of employment and get your full severance because you don't have to accept that kind of reduction. Or if your employer demotes you, or if you used to work days, now they want to change you to nights. All those things are big changes, and that could give rise to you saying, no, that's a constructive dismissal. So the question here for CSP is taking 1 week of vacation, so let's say instead of 4 weeks, now she's going to be 3 weeks, is that significant enough to be a constructive dismissal? The answer is probably not. Believe me, it's not fun. It's not a good thing to do. It's not the right thing to do. But strictly from a legal standpoint, it's not going to give you a lot of options here. So it's probably not enough to be a constructive dismissal. It's not considered that significant. So the best thing to do here, CSP, is to talk to your employer, to explain why that's unfair, and hopefully you can come to some sort of a compromise for this to work out. But ultimately, if they say, we don't care, we're going to take away that extra few days, there's not going to be a heck of a lot that you can do in that situation, just as a practical matter. So hopefully that makes sense. But for everyone else there, if your employer makes significant changes to terms of employment, remember, constructive dismissal. Now, if you just accept the change, then you walk away from your rights and you've given the company the right to do it again. Give you that example again. Let's say your pay gets reduced from 80 to 60, and you say, well, I'll be the good team player. I'll accept that reduction and continue working. The problem with that is because you've now accepted that reduction from 80,000 to 60,000, you've given the company the right to do it again. And the next time, if they reduce you from 60,000 to 40,000, you may not be able to do anything about it because you let it happen the first time. So you really want to be careful with that. If you're facing significant changes to terms of employment, hours, pay, responsibilities, give me a call. We should have a discussion about constructive dismissal. All right, great question. Thank you very much for that. If you're joining us, hey, I'm Lior Samfiru, the employment lawyer, with you, talking about employment law and your workplace rights. You have an opportunity now to ask your questions, to get answers. Questions are coming in, more have come. I'm going to get to them right now, but please, you can listen to me and learn, but you can also ask your questions. So don't be bashful. Get that question asked right now. All right, let's see. Jess has our next question. I wanted to know what can be done if you got terminated without cause. In my case, it's wrongful dismissal, as I had a doctor's note to show my absence. So it may not be a wrongful dismissal. It's a wrongful dismissal if you didn't get proper severance. Now, if you missed 2 days, of work because you're sick and your employer fired you, that is not necessarily illegal as long as proper severance is paid. Now, depending on the situation and how many vacation days you have, it may be illegal, but in most cases, it's a question of severance. Now, if you have a serious medical condition and you're going to be off and your company says, forget it, we're just going to let you go. No. That's a human rights violation. You can't be let go because of a serious medical condition. Okay? That's considered discrimination under human rights legislation. Not happening. But beyond that, it's just about severance. So, Jess, what I want to know in your situation is, were you offered severance, or and how much? For example, if the company said you're going to miss work, so we're going to let you go without severance, no chance. That is completely illegal. That is absolutely a wrongful dismissal. But as you see, it comes down to severance. It comes down to the amount of compensation. So that's what we need to discuss. So Jess, what I want you to do as soon as possible is I want you to connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Let's have that discussion. Let's make sure you get everything that you're owed. Again, employmentlawyer.ca. That address is on the screen right there. So check it out. All right, let's see. I'm Lior Samfiru, the employment lawyer. I am going to continue answering questions right now. You have time. Ask yours. Peter has our next question. Peter asks, what, if anything, can be done with a boss who calls employees very negative words, vampire, worthless person, etc., in front of other colleagues frequently? And this is directed to me. And others, to the point that my mental health is shot, and even wanting to go to work is a struggle. Would there be any sort of case to leave and obtain severance? Absolutely, there would be a case. So the first thing I would want to tell you, Peter, is there someone in the company that you can complain to? You can say this to HR, the owner, someone above this boss that's mistreating you. Is there someone like that? Because if you do, in writing, they have the legal obligation to investigate and to fix the problem, even if it means getting this person removed from the workplace. They have to, by law, figure it out a way to fix this issue. So that's your number one step. Now, if you've tried that and nothing happened, or maybe it's not even possible because this boss is the owner of the company and there's no one above him, well, then yes, that could absolutely be a constructive dismissal that allows you to leave with severance. But Peter, the key is to prove it. Remember, this boss is not going to admit, yes, I called Peter names, right? He's going to deny it. So what do we have to prove it? Is there a recording? Maybe you can record him saying that. Is there something in writing? Is there a witness? So we need to have the ability to prove it. Remember, this guy's going to lie. He's not going to hang his head in shame and say, yeah, I did it. So is there proof? Now, one way to build that proof is to even send them an email saying, boss, I'm very frustrated. You keep calling me names. I told you it's inappropriate and I'm asking you to stop. By doing that, you create that record. You help prove it. So yes, Peter, this can absolutely be grounds for leaving. If you can deal with it internally as a full step, I would like you to do that. If you cannot, give me a call and let's deal with it externally. Do not quit. Do not quit before we speak, okay? So Peter, to connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. Hopefully that makes sense, Peter. If you have a follow-up question, I'm still here. You got time. Let's make sure you get your questions answered. Now, I've talked already a few times about severance in answering questions. The question I always get when I mention severance, well, how do I know how much severance I get? How do I know if what the company is paying me is appropriate? Well, it's very, very easy to know. It's very easy to find out. I'm going to tell you how to do that right now. To find out how much severance you're owed, you just go to pocketemploymentlawyer.ca. You see that address on the screen right now, pocketemploymentlawyer.ca. When you go there, you just click on the severance calculator. That's all. And when you use the severance calculator, you can find out in seconds how much severance you are owed. Whether it's 6-month severance, 24-month severance, anything else, it's easy. It's free. It's anonymous. No names, no company names, no your name if you don't want to. You don't have to put an email address or a phone number, none of that. It's just there for you. And by the way, you'll be shocked by just how much you're owed. You will be shocked. In most cases, you're owed a lot more than what you realize, a lot more. You may think I'm owed a week per year of service or 2 weeks per year of service. No, you're not. Much, much more. You may have worked for a year and could be owed 6 months of severance. check it out. Again, pocketemploymentlawyer.ca. Always the very first place you go to if you lost your job or if you just want to understand how much severance the law says you should be getting. All right, let's see. Right now, though, I'm still live here. This is the live employment law session, your Q&A with me, Lior Samfiru, the employment lawyer. Let's continue answering questions, and please ask yours as well. Question on YouTube from Goki. Who pays for court fees when you have to go to court against your employer? Well, there's not really court fees. You don't pay the court any money, right? There's legal fees that lawyers charge. And generally speaking, law firms like us, most of our cases, not all, but most of our cases are on a contingency basis. And usually the loser pays winners legal fees. So that's how that works. But there's no court fees. You don't pay money to the court. All right, let's see. Jay has our next question. I work as a store manager. Let's see. Yeah, I work as a store manager for a wireless company. Sales have been down because our location has been less busy the last 2 years. The owners have written me up now because of the store's performance and have said that they want me to demote me and cut my pay. I've been there for 5 years and don't feel this is right. What are my options? So what I want you to do is respond. If they tell you you're not doing a good job or they give you bad performance and you don't agree with it, I want you to respond to it in writing and say, here's why I don't agree with it. Okay, here's why it's not accurate or not fair, or here's what you're not considering. Put that in writing. Make sure it's sent in writing. Okay, by doing that, you're protecting your job. And if in that situation they say, we don't care, we're going to demote you, constructive dismissal, absolutely. Because what they're potentially doing is they're trying to build a case to terminate your employment for cause so as to avoid having to pay you any severance. The way to respond to that, the way to fight that, is not to be quiet, to respond in writing and say, I don't agree, here's why. Be polite, be professional, but be detailed as well. So maybe the store is not performing well because there's construction around the building and people can't get in. Whatever it is, I don't know. You respond, and if they say you've done something wrong, you don't agree, say so in writing. If they do anything to your job, they cut your hours, they cut your pay, they demote you, they let you go, call me immediately, okay? Employmentlawyer.ca to connect with me and my team. Jay, very easy to do. Again, employmentlawyer.ca. Happy to connect and have a discussion. So thank you for that question. Fantastic. All right, if you just joined us, by the way, welcome. I'm Lior Samfiru, the employment lawyer, live here answering questions about employment law, about workplace rights, making sure that you're armed with knowledge when it comes to the rights that you have on your job. All right, let's see. Continuing to answer questions on this live session. Ask yours too, by the way. Gareth has our next question from YouTube. I was recently fired because of a disagreement with my manager. My employer told me I was only entitled to 4 weeks' pay. I disagreed because I've worked there for 8 years, but they said that was all I would get and sent me the amount with my last paycheck. I didn't sign anything. Is there anything I can do? Absolutely. You call me. That's what I do. I get people the compensation that they're owed. You can deposit the money they sent you. It's not a problem. No issue. As long as you didn't sign anything, no issue. Now, after 8 years, I don't know exactly how old you are and what kind of a job, but you could easily be owed a year's pay even. Not, like, forget about 4 weeks or 8 weeks. It could be easily a year, 12 months. So unless you did something terrible, and by the way, having a disagreement or even an argument, even a fight with your boss is not enough to deprive you of your severance. You're still going to be owed your full severance. So no, this is a wrongful dismissal. So yes, what do? You call me. It's that simple. And I get to work, my team gets to work, and we get you the compensation that you're owed. It's not complicated. There's no reason that before you go on your summer break, this isn't over. Okay, so contact me through employmentlawyer.ca and let us do what we do. All right, fantastic questions today, guys. Great questions. Keep them coming. I promise you, if you ask your question right now, I will still get to it before the end of the session. Don't ask it when I'm about to leave, because then I'm not going to get to it. Right now, you can still ask the question and still guarantee getting an answer. So don't wait. If you've been sitting and wondering whether you should ask, this is it. Ask the question. All right. Next question from, no, I answered that. Joe B. has our next question. When is a non-compete clause allowed to be enforced? If they are from an older contract, is that still valid? So for most employees, a non-compete is not enforceable. Now, a non-compete generally will only be enforceable if an employee is a very senior employee, an executive, someone with fiduciary responsibilities. In those very narrow set of circumstances, is the non-compete going to be enforceable? So that means with the majority of people, it's not enforceable. But guess what? It doesn't matter. And here's what I mean by that. The question is not, is it going to be enforceable? The question is whether your employer is going to try to enforce it. Here's what I mean by that. If your employer is going to try to enforce it, guess what they'll do? They'll sue you, okay? And then you'll fight them, and 3 years later and many, many tens of thousands of dollars later, you will win. But that's still going to be a pretty hollow victory. So you can't just say, well, it's unenforceable, so I can do whatever I want. Nothing's stopping your former employer from taking legal action against you. Now, they will lose, very likely, but they may not care. They may just want to hurt you, or they may want to send a message to their other employees. So the real question is not, is it enforceable? The real question is, will your employer try to enforce it? So probably good advice is, if you're going to leave and work for a competitor, talk to your employer, be honest, and say, hey, employer, I'm going to work for this other company, but you don't have to worry about it. I'm not going to hurt your business. I'm not going to try to steal your clients or employees. I'll be on my best behavior. So hopefully this is okay. That's the better way to do that, rather than say, well, it's not enforceable, so I'm going to work wherever I want. Potentially, you're opening yourself up for legal action then. So Joe B, hopefully that makes sense. If you have any follow-up questions, I'm right here. All right, by the way, Lior Samfiru, that's me, the employment lawyer with Samfiru Tumarkin LLP. I'm going to continue answering questions. You still have time to ask yours as well. Linda B has our question next. Off work for medical/mental health. Employer is saying I have to return by the end of the month per their policies. My doctor and psychiatrist say I need another month. They said resign or be laid off. This is just incredible. I mean, what the heck is this employer thinking? Nonsense, ridiculous. You can be off as long as you need to, so long as you have your doctor's support. So make sure you give them an updated doctor's note saying you're still going to be off for another month or two, or however long you need to be off. Give them that doctor's note. Psychiatrist is fine, or family doctor, but it has to be an actual doctor. If they do anything to you, human rights violation, employment standards violation, illegal, completely wrongful dismissal, you name it, can't do anything to you. So give them that doctor's note. If they try to do anything, you call me. I assure you we'll be able to get this resolved. No, the company doesn't get to decide how long you're going to be sick. Imagine, sorry, under our policies, you can only be sick for 3 weeks. Well, what happens if I'm sick for 4 weeks? Too bad. You tell your illness that that's a breach of policy. It's absurd, right? So you can be off as long as you need to, so long as you have a doctor support. So Linda, give them another doctor's note. Anything happens, I'm right here, employmentlawyer.ca, to connect with me and make sure that you're protected. Yeah, so Linda, and you're saying that they're not-for-profit who support women's health and well-being, and this seems contradictory. Yeah, it's contradictory, but forget about contradictory. It's completely illegal. So you know now better, and this is what you're going to do. You're going to contact me, and I'll help you. Employmentlawyer.ca, but give that doctor's note. All right, let's continue answering questions. Guys, let's see. Peter has our next question. I record my boss whenever we have a one-on-one discussion, but I will have to catch him calling me and others vampires in a recording at some point, because he does this to 4 people he really dislikes. Yeah, so like I said, if you're going to pursue something because of the way your boss treats you, there has to be a way to prove it. If you say it happened, your boss says it didn't happen, it's a problem unless you have something to kind of break the tie. So recording is helpful. If you have someone willing to corroborate it, that works too. So you're on the right track there, Peter, absolutely. All right, continuing with questions. By the way, maybe you can get your question answered as well. You kind of squeeze it in under the wire. Again, I'm Lior Samfiru, the employment lawyer, answering questions. Ruel has our next question. I have been managing out by I'm not sure you mean managing out by my company aggressively. Don't know exactly what you're saying there. By sending me email warnings due to performance issues. I have not answered some, but I drafted a response. I have not sent it. Okay, so the sounds of it, they're giving you bad performance reviews or performance improvement plans. You have to respond well. You absolutely have to. Okay, but read it again before you send it up. Make sure that it's you're not being aggressive. You're not calling them names. You're not flinging accusations. You're just giving them the facts. I don't agree with this, and here's why. Okay, or this didn't happen, and here's why. Facts. You have to send it. Don't sit on this. Okay, you got to do it because your silence is the same as acceptance. So if your employer is saying you did all these things wrong, so you don't say anything, it's exactly the same as if you've said, absolutely, I did, I agree. And that's a problem. That could potentially be a basis for the company later on to consider letting you go for cause. Don't do that. All right. Sammy, next question. Can an employer change work from home policies? I was hired remotely, but management has said that they are going in a new direction and want everyone in the office saying abandonment if we didn't go. So here's the thing. It's not abandonment if you don't go. If they decide to let you go because you're not in the office anymore, it's a without cause termination, meaning you have to get paid severance. So the thing is this. You can still lose your job if you don't go in the office. Why? Because an employer can generally let you go at any time and for any reason. So they can let you go because of it, but it's not a resignation. It's not a for cause termination. It's a termination without cause. They have to pay you severance. So ultimately, what you're going to have to decide is what is better for you. Is it better to continue working in office like they're demanding, or is it better to lose your job with severance? Obviously, that's a decision that you have to make, but I'll leave you with this thought. Before you tell them, no, I'm not going in, too bad, call me, because we need to assess exactly how much severance that you're owed so that you can make an informed decision. It's one thing if you get 1 month severance, another thing if you get 2 years severance. So if you want to go into work, no problem. But if you decide I'm not going in, before you tell them, before you actually make that decision, call me and let's assess what you would be owed so you have all the information. Sammy, hopefully that makes sense. To connect with me, my team, very easy. You could do it today. You could do it whenever you want. employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see if we can get some more questions answered. Hobby Lover asks, can I terminate myself and get severance because management wrote me up and treated me unfair compared to other employees? I have lost my interest in the job. I'm on short-term disability and planning to resign. Well, it may be tough to get severance because they wrote you up, unless you can show they were completely out of line and they were just picking on you to try to hurt you. Generally speaking, what I would want you to do is to respond to this and say, I don't agree that you wrote me up. I don't think you're doing this properly. Now, unless the treatment was very, very bad and you can prove it, then you won't get severance. Now, if the treatment is bad, if you can show that they were completely trying to hurt you, then that would be a constructive dismissal and you can leave with severance. So obviously, Hobby Lover, the devil's in the details. I'd want to see what they said, what happened, etc. So call me so I can do that analysis before you resign. Okay, not after. Call me before so we can do this correctly. To connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. Let's see. All right, I'll do a last follow-up question from Sammy. Sammy asks, Sammy was talking about being forced to go back to work instead of remote, to work in the office. Would that be the same for those who started in office or just for those hired remotely? There are several employees who relocated because of the remote work. If the employees have been working remotely for a long time, let's say a couple of years or more now, even though they may have started in the office, the same thing applies. If their employer says, come back to work now, then if they choose not to, that may be a termination without cause, meaning they're owed severance. It's not a resignation. It's not a job abandonment. But again, before they do anything, they should call me so that we can assess what they're owed. And they should know that before they make a decision. Hopefully that makes sense, Sammy. So have them contact me through employmentlawyer.ca. Guys, this is the time that I have for today. I got through all the questions as I always try to do. Thank you so much for asking questions. Thank you so much for joining me and participating in this. When you ask me questions and you give me the opportunity to respond, you're also helping other people who may have the exact same questions. If you need to connect with me and my team, now that we're done, very easy to do. employmentlawyer.ca, the way to do so, available. We'll be back next week. I'll be back next week, but don't wait. Actually, I won't be back next week. I'll be back soon enough. But don't wait until then. You can connect with me today, tomorrow, next week, anytime, employmentlawyer.ca. Thank you so much for joining me. Have yourself a great day. I'm Lior Samfiru, the employment lawyer. Thank you. Bye now.